Hi. In this segment, I'm going to talk to you about the type of information that you should be able to pull out any of the cases that you're reading for class. Before you start, you need to determine some context. Why are you reading the case? If you're reading a case for a doctrinal class, the syllabus or the table of context in the textbook will help you figure out what the professor is focusing on for that particular case that you're reading. If you're reading a case for legal practice, you may be reading a number of cases all about the same legal issue. For example, 5 different cases about a tort called intentional infliction of emotional distress. In that case, when you're reading each of those cases, you should be thinking about the case in the context of those other cases. Are the cases describing a history of a cause of action? Does the cause of action change over time, broaden, for example, or narrow, for example? How do the cases relate to each other? Also, if you're reading a case for legal practice, you may well be reading a case that helps you answer a legal question, often a fictional client's question about, for example, whether they can pursue a particular legal cause of action. In that case, you'll have a fact pattern of events that have occurred for the client, and you want to be able to compare that fact pattern with the fact pattern of the case that you're reading for legal practice. Additionally, as you read, a few hints. The first, you've got to be an active reader when you're reading legal cases. You've got to mark it up. You've got to use highlighter, pens, circling, underline, whatever works for you. Studies show the more you mark up a text, the more likely you are to be able to understand and comprehend the information in that text. Also, look it up. If you encounter terms that you don't know the definition for, such as sui generis or sub judice, you need to look it up and understand what the court means by those terms. Your professors are going to assume that you know the meaning of every word in that case. And finally, as you begin to read these cases, be a little bit skeptical. Question everything that you're reading. Don't assume that the court has reached the right decision. Don't assume that the court's reasoning is good reasoning or that it's justified. So keep that in mind as you move forward. Okay, as you read cases, many of you will brief the case. Whether you do that on a separate piece of paper or whether you brief the case simply by marking it up as you read, there's certain key information that you should be looking for. And I'm going to kind of identify each of these key pieces of information in a particular case that you've been assigned, the 3-page case of Hedging v. Community Counseling Center of Fox Valley. If you haven't read that case yet, you should pause this video now and go back and read that case. But assuming you have, let's look at the type of information that you should be pulling out. You need to be able to identify the court, the procedural posture, the parties, the factual circumstances, the legal issues being debated, and then the all-important holding of the case, which includes the court's reasoning. And those two are almost always the two most important pieces of the case that you'll be reading. But you nevertheless need to know the rest of the information that's identified here as well. So let's take a look at the Hedging case. First, you need to determine which court you're in. Are you in federal court or are you in state court? And then if state court, which state court? And what level of court? Is this a trial court opinion or is it an appellate opinion? First level of appellate court, final appellate court, etc. So that information is usually found in the caption of the case, as it is here where you can see with the blue arrow that we're in a federal court and that it's a trial court, the United States District Court, specifically of Northern District of Illinois. With that, you also want to figure out where in the life of the case this decision is appearing, the procedural posture, in other words, of the case. And here the court has told you it's very early on in this case. Defendants filed a motion to dismiss for failure to state a claim. So if you remember from the last segment, that means that the plaintiff has filed a complaint and the defendant has immediately moved for a motion to dismiss. Okay, next you need to identify the parties with some specificity. Since we're looking at a trial court opinion, you're going to be identifying the plaintiff and defendant. If this were an appellate level opinion, you would be looking to identify who appealed, the appellant, and the appellee. So here the plaintiff, as the court tells you, is Elaine Hedgie, and she's 78 years old. Anytime the court gives you a little bit of additional information about who the plaintiff is, it's a pretty good bet that that information is going to somehow come into play in the court's decision, and you'll see that it does in this case. The defendants in this case are the center that employed plaintiff and 3 of the corporate officers of the center. The president, the treasurer, and the replacement. And these symbols that I'm using here are just a shorthand for plaintiff and defendant. Might be useful for you as you're taking notes. Usually also you want to think about the relationship between the parties. Not always, but often that comes to bear in the court's decision. It matters. That relationship matters. Here it does matter, and here the relationship is employee to employer. Okay, as you start to read the facts of the case, I really think you should read them twice, and that's what I do. The first time I read the facts of the case, I'm just trying to figure out what happened. And I think of those as kind of the background, essential facts. What's going on in this case? And I've highlighted some of the facts of this case that tell the story. Because after all, these decisions really are stories. They're stories about what happened between 2 people or 2 entities. And here the essence of the story is that defendant, after a few false starts, eventually gets around to firing the plaintiff and does so while she's out on sick leave by simply locking her office and then posting a sign stating that she's been terminated. Once you read the rest of the case, you should think about coming back and looking at the facts of the case and really trying to pinpoint what I call the operative or determinative facts, the ones that made a key difference to the outcome of the case, that the court relied upon in making its decision. Okay, after looking at the facts of the case, you'll want to identify the legal issue or issues at stake. And here the court tells you those legal issues in a pretty straightforward, easy way, which is kind of nice. That doesn't always happen. But the court tells you that presently before the court is the defendant's motion to dismiss on this issue of intentional infliction of emotional distress that I'll abbreviate IID throughout the rest of this segment. And specifically, since it's a motion to dismiss, whether the facts as stated by plaintiff can set forth the extreme and outrageous conduct that's required in order to prove IID. So once you've established the legal issue, you need to look at the precise question that the court is asking itself. Sometimes the court is trying to figure out what the rule or the standard should be for the legal issue. In other words, what should the rule be that governs intentional infliction of emotional distress, or IID? In this situation, the test is pretty clear. So that's not, in fact, what the court is doing. The court tells you it's a 3-element test. And anytime, frankly, that you see an enumerated list like you do here, the 1, 2, 3, pay attention. Often that is the court's way of describing to you the test with some nice specificity. Here, a 3-element test. Each of these 3 things must be present in order for the plaintiff to win her claim here. But here, test is clear. Court's not trying to determine what the rule should be. So then sometimes the court says, well, I know what the rule should be. How should it be applied in this situation? And that is what the court's doing here. And specifically, the court tells you that defendants contend that the plaintiff has failed to allege the first element of the rule, the outrageous conduct, and the third element of the rule. But you'll notice there's a footnote here. Got to read the footnotes, every single one of them. And in that footnote, the court gets rid of the question of whether element number three has been satisfied or not. And the court says, yes, for this purposes of this motion, we're going to assume she has severe emotional distress. So the very specific legal question that is being asked by this court is whether the facts of the case can be considered extreme and outrageous. So it really just comes down to element one of this three-element test. And the court going forward is going to focus specifically on that one element. Okay, sometimes you'll read a decision in which a court is trying to both determine what the rule should be and how that rule should be applied. And the court isn't doing that in this case, since we've already established that the court knows definitively what the rule for IID should be. Okay, now that you've identified the parties, the facts of the case, and specifically the legal issue that the court is going to decide, your next step will be to look at the holding of the case and the legal reasoning of the case. And we'll pick that up in the next segment.